Good morning. I hereby call to order this meeting of the Pennsylvania Public Utility Commission for the year 2018. It is the 9th meeting, excuse me. But I ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Noting the fact that June is National Safety Month, it's just a reminder also for you to look on our agenda. If there is an emergency in the building, you know how to exit the room. The first matter on this morning's agenda is the approval of the minutes for May 3rd, 2018, and I recognize Commissioner Coleman, who is the editor.
Thank you, Madam Chairman. I've reviewed the minutes of the May 3rd, 2018 public meeting, and I move that they be approved as submitted.
Second.
You have heard the motion of Commissioner Coleman and the second of Commissioner Kennard for the approval of the May 3rd, 2018 minutes. Wow, is there any further discussion or edits or anything of that nature? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. So, at this point, I do usually call on another person to lead us through our agenda, but we have a new person to lead us through. Madam Secretary Rosemary Chiavetta will be leading us through today's agenda, now and in the future.
As long as it lasts. Thank you, Madam Chairman. Good morning, Madam Chairman and Commissioners. Your bureaus and offices have prepared the following agenda for your consideration, beginning on page 1. It is recommended by Director Monahan and the staff of the Bureau of Audits that the Commission adopt the audit report of UGI Penn Natural Gas.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? Second. Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to matters presented by Acting Director Marinko and the staff of the Office of Special Assistance. At the top of page 2, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of the Office of Attorney General and the Office of Consumer Advocate versus Blue Pilot Energy.
Is there a motion to call up the matter for consideration?
So moved. Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion?
Madam Chairman, I have a motion on this matter.
Commissioner Coleman.
Thank you. I'd ask that my motion be entered in the record as I read it in its entirety. Before the Commission for consideration and disposition is the initial decision sustaining in part, denying in part, the formal complaint filed by the Pennsylvania Office of the Attorney General and the Pennsylvania Office of Consumer Advocate against energy supplier Blue Pilot Energy, LLC. The formal complaint arose out of numerous consumer contacts and complaints related to the variable rates for electric supply service charged by Blue Pilot at the end of 2013 and early 2014 following the polar vortex. My motion proposes to affirm the initial decision that the joint complaints met the burden of proof as follows. Number 1, that Blue Pilot failed to provide accurate pricing information to customers in its disclosure statement. 2, that Blue Pilot failed to conform prices to its disclosure statement. 3, that Blue Pilot made deceptive and misleading promises of savings to customers. And 4, that Blue Pilot failed to exercise good faith in handling customer complaints. As relief, my motion directs Blue Pilot to pay a civil penalty in the amount of $1,066,900 for overbilling customers from December 2013 through March 2014 in violation of the Commission's Chapter 54 regulations. This penalty amount constitutes $125 per violation for the occurrences of overbilling of residential customers and $150 per violation for the occurrences of overbilling of small business customers, and it's consistent with the pre-violation penalty amount imposed by the Commission in BINE versus HEICO, which is a similar case that is currently on appeal. As relief, my motion also proposes to revoke Blue Pilot's license and direct Blue Pilot to remit $2,508,499 into a refund pool to provide billing adjustments to the relevant variable rate consumers that have been overcharged December 2013 through March 2014 in violation of the Commission's Chapter 54 regulations. Therefore, I move the exceptions of Blue Pilot Energy LLC are granted in part and denied in part consistent with this motion. 2, the initial decision in the matter be reversed in part consistent with this motion. 3, that the petition to intervene filed by the Retail Energy Supply Association is denied consistent with this motion, and that the Office of Special Assistance draft an opinion in order consistent with this motion.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion?
I have a statement.
Vice Chairman Place.
Thank you. I believe that the record in this proceeding fully supports both the amount of the refund pool and the civil penalties as determined by the ALJs. Because of this record, I cannot support the motion.
Any further discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1. On the matter as amended, is there any further discussion? Is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 4-1, noting the dissent of Vice Chairman Place.
Continuing on page 2, in omnibus motion, it is recommended the commission adopt the staff recommendations, beginning with the complaint of Mary Paul versus Pico Energy, and all of the items on page 3, including and ending with the complaint of the Bureau of Investigation and Enforcement versus BA Hawk Trucking.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by, which one of you was?
Sweet's good.
Commissioner Sweet.
See how this is going to go.
Okay. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4, it is recommended that the commission adopt the proposed opinion and order in the complaint of Hudson v. Pico Energy.
Is there a motion to call up the matter for consideration?
So moved?
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
Madam Chairman, I have a motion on this matter.
Commissioner Coleman.
Thank you. I'd ask that my motion be entered into the record as though I read it in its entirety. Before the commission are acceptance and reply exceptions to the initial decision of the Administrative Law Judge Darlene Heap on June 28, 2017, dismissing the formal complaint for failure to prosecute and meet the burden of proof. The Office of Administrative Law Judge initially scheduled an evidentiary hearing in the matter on October 14, 2016. On October 4th, the commission was informed by PICO that the complainant had filed for bankruptcy, and accordingly, the presiding hearing canceled. On January 9, 2017, the commission was informed by PICO that the bankruptcy petition had been dismissed. In response, the ALJ rescheduled the evidentiary hearing on April 7, 2017. The complaint was sent a standard hearing notice with the date, time, and location of the April 7, 2017 telephonic hearing. The notice also stated that the case would be dismissed if the complaint did not appear at the scheduled hearing. Approximately 2 weeks before the hearing, the complainant telephoned the ALJ and requested that the hearing be converted into an in-person hearing. The request was approved by the commission. The day before the scheduled hearing, the complainant telephoned the ALJ and requested that the in-person hearing be converted back to a telephonic hearing. Again, the commission accommodated the complaint relating to participation in the hearing process. On April 7, 2017, the ALJ convened the hearing as scheduled. PICO's counsel was present in person with one witness and ready to proceed. The complainant was not. The complainant was called 3 times over the next 21 minutes at the cell phone number that had been provided to the ALJ but did not answer. After the 3rd call, PICO moved to dismiss the case for failure to appear, and the ALJ said that she would grant the motion and issue the initial decision. The presiding ALJ later issued the initial decision and granted PICO's motion to dismiss the case. The complainant filed exceptions and requested a new hearing. PICO filed reply exceptions asking that the ALJ be affirmed. In reviewing this matter, I'm guided by the provisions of the Public Utility Code and our regulations that provide that parties who fail to participate in scheduled conferences be deemed to have waived the opportunity to participate and not later be allowed to reopen the matter. The Commission is permitted, however, to excuse the absence if it finds that the failure to appear was unavoidable and that interest of the other parties and the public would be prejudiced. Based on the review of the record, I cannot conclude that the complainant's non-participation in the April 7, 2017 hearing was unavoidable. The complainant alleged that a family member had a medical emergency in the morning of the hearing and that required treatment. He also advised the ALJ that he could provide evidence to this. The complainant had opportunities before the issuance of the initial decision and through his exceptions to document his occurrence, but has failed to do so. Accordingly, PICO is persuasive that further delay in this case is prejudicial and that the interest of the public. PICO stated that it is unable to pursue collection of the outstanding $22,259 balance due to the complainant's actions, which include the filing of 18 informal and formal complaints, and it is non-participation in the proceedings. Overall, I conclude that the complainant was afforded robust, due notice and opportunity to be heard. Accordingly, I move that the exception be denied and the initial decision be affirmed in its entirety. Therefore, I move that the initial decision of Administrative Law Judge Darlene Heap be affirmed and that the Office of Special Assistants prepare an opinion order consistent with this motion.
You've heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion? I do have a comment to place on the record, and I asked it to be placed on the record in its entirety, and I would just summarize it for you. I will be supporting Commissioner Coleman's motion, but there is something that I really want to point out for the record here. You've heard him say that there was sufficient, the regular hearing notice that we send out, but there's also, in many matters, a pre-hearing notice. And that's important to me, and I think it's important for this particular case because it provides a lot of invaluable information, especially for pro se litigants. It provides information of how to address the request for hearing continuances, subpoena procedures, attorney representation, and as well as the Commission's policy encouraging settlements. As I've been I don't say I was the only champion for pro se litigants, but I've been very consistent with saying that they need to have this information to be able to allow them to have their day in court. With the failure to have that in this particular case, I thought it was something that we were missing here in this case. So even though I will support the motion, that is a concern of me in this case. Any other further discussion? Hearing none. On the motion, all those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing none, the matter as amended passes 5-0.
Continuing with an omnibus motion, on page 4, it is recommended the Commission adopt the staff recommendations, beginning with the 2 remaining items on page 4, all of the items on page 5, including and ending with the petition of Pike County Light and Power Company and the Leather Stocking Gas Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 6 of the agenda, it is recommended that the Commission adopt the proposed opinion and order regarding the petition for reconsideration of the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion?
Madam Chairman, simply a statement that I ask be entered in the record, assuring the parties that Rachel Maurer, who is now with my staff, but at the time participated, is a financial analyst at the Commission's Bureau of Investigation and Enforcement, did not advise me in this matter.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the proposed opinion and order in the complaint of Ferguson versus Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 7 of the agenda, it should be noted that all of the items on page 7 are postponed to the public meeting of July the 12th. Therefore, we will turn to page 8. And in an omnibus motion, it is recommended that the commission adopt all of the items on page 8, beginning with the EE&C Plan of Peoples Natural Gas, as well as the single item at the top of page 9, the joint petition of CenturyLink and Blockline Systems.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10 of the agenda, and the items presented by Director Diskin and the staff of the Bureau of Technical Utility Services. In an omnibus motion, it is recommended that the commission adopt all of the items on page 10, beginning with the application of Wide Voice LLC, all of the items on page 12, and going to page 11, and turning to page 12, the first two items regarding the applications of a North Penn long distance.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 12, in an omnibus motion, it is recommended that the commission adopt the proposed orders regarding and including Consolidated Communications of Pennsylvania, Windstream Buffalo Valley, Windstream DNE, including at the top of page 13, Windstream Conestoga, Windstream Pennsylvania LLC, and dropping down to the last item on page 13 to include Northeastern Pennsylvania Telephone Company, and skipping over to page 14 to include in the omnibus motion the Lackawaxen Telecommunications Services, Mariana and Scenery Hill Telephone Company, Bentleyville Communications Corporation, and finally, the Hickory Telephone Company.
Is there a motion to call up these matters for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Is there any discussion?
Yes, Chairman, I have a motion on the matter.
Vice Chairman Place.
All right, thank you for the recitation of all the cases. Madam Secretary, I
Yes.
ask that my motion be placed in the record as if I read it its entirety. My motion encompasses 10 cases on today's public meeting agenda as noted. Before us for disposition are the 2018 Annual Chapter 30 Price Stability Index and Service Price Index submissions of 10 rural incumbent local exchange carriers that operate under their respective alternative regulation and network modernization plans. With the partial exception of Lackawaxen Telecommunications Services, these PSI-SPI submissions do not result in any actual rate increases, since these rural ILECs have chosen to bank their respective annual revenue increases for future use. Lackawaxen is proposed to implement an annual rate increase that will total $312, while also choosing to bank the remainder of its allowable annual 2018 PSI-SPI revenue increase. The Office of Consumer Advocate has filed formal complaints against all of the 2018 PSI-SPI submissions from these 10 rural ILECs. The OSA formal complaints generally allege that the results of the price stability mechanism and PSI and SPI formula for each of the rural ILECs should be adjusted for the exogenous event factor and through the proper recognition of the effects of the Federal Tax Cuts and Jobs Act of 2017. On May 24, 2018, the rural ILECs were granted time extensions from this commission to submit their respective answers to OSA's formal complaints on or before June 25, 2018. Furthermore, the Office of Small Business Advocate has formally intervened in these adjudication proceedings. I agree with the approach that the various 2018 PSI and SPI submissions be placed into effect while the OSA formal complaints are properly referred to and adjudicated before the Office of Administrative Law Judge. The same holds true for the rate increase change proposed by Lackawaxen. This is fully consistent with past commission practice regarding annual Chapter 30 ILEC price stability mechanism, annual revenue, and rate submissions where formal complaints were involved. However, this practice has also explicitly recognized that the subsequent formal complaint adjudications may result in appropriate rate adjustments and/or rate refunds, as well as other accounting adjustments. Therefore, I move that 1, the annual Chapter 30, 2018 PSI-SPI submissions of the rural ILECs referenced in this motion be accepted as being procedurally consistent with the ILECs corresponding alternative regulation and network modernization plans, and be permitted to go into effect subject to the adjudication of the corresponding Office of Consumer Advocate formal complaints before the Office of Administrative Law Judge. 2, the cases referenced in this motion be assigned to the Office of Administrative Law Judge for the adjudication of the Office of Consumer Advocate formal complaints, the issuance of corresponding recommended decisions, and for the consideration of any potential rate effects and accounting adjustments that may be or are subject to appropriate rate refunds. 3, the existing procedural status of each proceeding and the intervention of the Office of the Small Business Advocate be appropriately noted. 4, the rate adjustment proposed by Lackawaxen Telecommunications Services Incorporated go into effect as proposed, subject to the adjudication of the associated and pending formal complaint by the Office of Consumer Advocate. 5, the Bureau of Technical Utility Services timely prepare the appropriate orders consistent with this motion, and that the orders be served to the parties of record in each proceeding affected by this motion. Thank you.
You have heard the motion of Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended by the motion, if there's no objection, we'll take the previous roll call. Seeing no objection, the matters as amended are passed 5-0.
Madam Chairman, we will now briefly return to page 13. And in the center of page 13, in an omnibus motion, it is recommended that the Commission adopt both proposed orders in the applications of Selectel Incorporated and Global Energy LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, we will now return to page 14, and at the very bottom, in another omnibus motion, it is recommended the Commission adopt PPL's letter of notification. All of the items on page 15, including and ending with the application of Phoenix Fuel Management Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 16 in matters presented by Chief Counsel Panque and the staff of the Law Bureau, it is recommended in an omnibus motion that the Commission adopt all of the items on page 16.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 17 in matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt ALJ Brady's initial decision in the complaint of Morales versus the Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Madam Chair, I have a motion.
Commissioner Sweet.
I ask that my motion be placed on the record as if I'd read it in its entirety. In this formal complaint, Maria Morales objects to the Philadelphia Gas Works terminating her service and backbilling her for estimated usage from the date that her meter stopped reporting usage to the date of termination. Ms. Morales was in PGW's Customer Responsibility Program, CRP, and paid her CRP amount regularly. In fact, she paid her CRP payment for 23 months following the date that her meter stopped reporting usage, until during a visit to a PGW office to recertify for CRP on February 1st of 2016, a PGW representative removed her from CRP because billing for her usage, which at that point was zero, was lower than the CRP bill of $99 per month. PGW, whose system is equipped with automated meter reading, knew or should have known as early as February 20th, 2014, that Ms. Morales' meter was not recording usage. Although PGW made several attempts to access the meter, none was successful until July 27th, 2017, 3.5 years later. During that time, Ms. Morales successfully re-enrolled in the CRP program at least once and maybe twice, and attempted to re-enroll again without causing PGW to act at all. Finally, PGW sent a technician who found that the meter had been tampered with and terminated service. PGW backbilled Ms. Morales for full estimated usage, minus the actual payment she'd made, for the period of time from February 20th, 2014 through July 27, 2017. In fairness, Ms. Morales only benefited from the tampered meter from the date of her last attempt to re-enlist in CRP, and accordingly, PGW can only bill her for estimated usage from February 1, 2016 to July 27th, 2017, minus the payments made. As meter tampering constitutes fraud, and no statute of limitations applies to the utility's ability to recoup unbilled usage, there sadly seems to be little incentive for PGW to act quickly upon the suspicion of a faulty meter. But PGW is hereby warned that a single failed attempt to view the meter followed by 3 years of relative inactivity is just not acceptable. Accordingly, the total amount, by the way, I should also add, the record is very murky regarding the alleged meter tampering, who caused it, what happened, and how it was rectified. But accordingly, the total amount of estimated usage should either be figured from 2016, or should be figured from February 2016 at the CRP rate, not an imputed usage rate. Therefore, I move, number one, that the complaint filed by Maria Morales against Philadelphia Gas Works at this docket is granted in part and denied in part. Two, that the amount that Philadelphia Gas Works may charge for unbilled usage is the amount accrued from February 1, 2016 to the date of termination at the CRP rate that would have applied had she been re-enrolled in CRP at that date. Three, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second?
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. On the matter as amended, any further discussion? If there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Continuing on page 17, it is recommended that the commission adopt ALJ Dunderdale's initial decision in the complaint of Hardison versus the Pennsylvania Electric Company.
Is there a motion to call up the matter for, is there a motion to adopt staff recommendation?
So moved?
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? I do have a statement for the record and ask that it be placed on the record in its entirety. On September 11, 2017, Jerome Hardison filed a formal complaint alleging there were incorrect charges on his Penelec bill due to a malfunctioning meter. A hearing was scheduled for February 28, 2018 at 10 a.m. On that day, before the hearing, a voicemail notified the Office of Administrative Law Judge that Mr. Hardison could not attend due to a mandatory workday on February 28th, that his wife had to work as well, and he would like to continue. Like a continuance. On the morning of the 28th, the Office of Administrative Law Judge notified Mr. Hardison that a hearing would convene as scheduled. Mr. Hardison stated that he could not attend, but that his wife would call in. The hearing was convened, and neither the complainant nor his wife appeared. The Administrative Law Judge dismissed the case with prejudice. At the hearing, both the ALJ and the opposing counsel indicated that they expected either the complainant or his wife to appear to explain the need for the continuance. Expecting the Hardisons to appear at the hearing when they had already indicated they both had to work makes no sense. If they could appear at the scheduled hearing to explain the need for continuance, no continuance would have been needed. Because Penelec's answer states that the complainant's wife is an authorized contact for the account, it is unclear what role she would play in the prosecution of the complaint. Having Mrs. Hardison appear at the hearing when she is neither the customer of record nor an attorney authorized to represent the customer of record also seems to be a waste of time. Because the ALJ's pre-hearing order warned of the consequences of not appearing at a hearing and advised the parties that any continuances should be sent at least 5 days in advance of the evidentiary hearing, I agree with dismissing the complaint, but without prejudice. A party to a proceeding has the right to request a continuance of a hearing, which may be granted by the presiding officer for good cause pursuant to Section 1.15B of our regulations. While the request for a continuance here was untimely, I believe that this complainant's reason for a work conflict, qualifies as a good cause. I have previously expressed concern regarding the Commission's practice of dismissing pro se complainants with prejudice as being inconsistent with Section 1.2 of our regulations and the Commission's own case precedent to subject the Commission's administrative process protects the complainant's right to due process. While any further discussion on the case?
Concern regarding what may sometimes seem to be harsh outcomes when commission rules are imposed upon self-represented complainants. There's been considerable discussion regarding whether the proper way of hearing is to dismiss those cases with or without at issue on a case-by-case basis, or perhaps in our own procedures. A self-formal adjudication by filing a complaint proceeds by the same rules as those formal process are expected to abide. Now, the ALJs issue pre-hearing orders which provide considerable direction. The direction, as has been mentioned, is to ALJ all at least 5 days ran afoul of those rules. Administrative law judge, the afternoon before, and that she also had to work, and therefore they suggest that instead of continuing, the commission consider developing guidelines for what's during the 5-day period before a hearing. For example, there are and are expected to show up for such a situation, and we ought to have our rules at our concern. Moreover, that formal litigation, which this is risky business. Formal options which are available. Thank you.
On this matter.
Commissioner Coleman.
Thank you. Chairman has laid out this morning. I think we all agree for the most part in that. I wish to note that I'm fully satisfied that the commission, which the moving party does not participate in the evidence, Section 332F of the Public 5 of our regulations, regulatory provisions on such questions in the provided decision. The updated is the process for reviewing to provide that the continuance should only be granted for at least 5 days before the scheduled hearing as noted. Notify the respondent of the request. Discretion to excuse non-compliance. I find it appropriate that the continuance, including the reasons for the request and whether neither the complainant nor spouse participated in the hearing, a presentation that the spouse would participate. My general experience has been that public utilities are not opposed to requests for continuance, even untimely ones. I've also found that our ALJs overall to be reasonable in their view of such request. Going forward, I would encourage all utilities to continue this practice and remind our ALJs to explain why they are or not granting the continuances to their initial decisions with the appropriate reliance on good cause shown standards of our regulations. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further comments? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Finally, on page 17, it is recommended that the commission adopt ALJ Hoyer's initial decision in the complaint of Yost versus the Pennsylvania Electric Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, joint second by Vice Chairman Place and Kennard. I heard you both equally well.
Just take one.
Any discussion on this case? I do have a statement to place on the record. The complaint filed in this initial complaint in 2016 was about charges for consumption at an older address compared to a new address. After failing to appear and the case was dismissed with prejudice, the complainant filed a second complaint in 2017 seeking a hearing on the 2016 complaint, but also raising new claims about faulty equipment at the first address. The ALJ dismissed the second case with prejudice because the matter had already been adjudicated in a prior order, essentially a finding of res judicata. I do not agree that a dismissal of a complaint for failure to appear is equal to a dismissal on the merits for res judicata. Apply if a party fails to appear because there has been no substantive failure to appear is not a decision on the merits. My opinion of the code. This section addresses prima facie evidence of facts found, which are conclusive unless set aside. This are reasonable and precludes collateral attacks upon those facts absent a showing of changed circumstances. There were no facts entered into a record here other than the complainant's failure to appear. Since there are no facts to create prima facie evidence under Section 316, 316 cannot sustain this decision. And with that, I will be dissenting in this case. And I do have a full statement that I asked be placed on the record. Any further comments?
Madam Chair, I have a brief statement.
Commissioner Sweet.
Sadly, I disagree.
Okay.
Thanks. In March 2017, this commission decided the case of Hattie Beatrice Howell versus PGW on the same issue that's before us today, whether dismissal of a complaint when the complainant fails to show up for the hearing will act as a bar against refiling the same complaint. Ultimately, we decided that Section 316 of the Public Utility Code provided the legal support needed to support the dismissal of a second complaint filed on the same subject matter because an order of the commission remains, quote, conclusive upon all parties affected thereby, unless set aside, annulled, or modified on judicial review, close quote, which has not occurred here. In this case, the ALJ adopted the reasoning set forth in the commission's opinion and order in Howell and issued the appropriate initial decision, which is why I'm supporting that initial decision today.
Thank you very much. Any further comments?
Chairman, I'd like to associate myself with Commissioner Sweet's statement this morning, and I would also note that there's been some discussion about the merits of this case, particularly around res judicata being used as the basis to arrive at this conclusion. But I would note that in this decision that res judicata is not in any of the pleadings of the parties, nor is it mentioned as part of the initial decision of the administrative law judge, nor of the OSA opinion and order. Consistent with our statement in the previous case, the Hardison case that was just before us, I don't believe that this is appropriate of precedent of the Public Utility Code is inappropriate at this point. So thank you.
Thank you, Commissioner Coleman. And I can also further restate that in my review of this case and the concerns that I had, I do believe that res judicata was discussed. It may not have been in the conclusions of the ALJ's initial decision, but it was part of the discussion where they made the review. And so that is why I stand on my concern about this case, and I will be dissenting. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? I will be opposing. The motion passes 4-1, noting my dissent.
Turning to page 18, it is recommended that the commission adopt ALJ Johnson's recommended decision approving the settlement of the rate investigation of National Fuel Gas.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman, that concludes the regular agenda. Turning to the carry-in agenda. On page 1 from the Office of Special Assistance, it is recommended that the commission adopt the staff recommendation of the petition of First Energy Solutions.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion, I do have a motion, so I'll turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be spread upon the record and in its entirety, and I will summarize it for you. Before the commission is the petition for reconsideration of staff action filed by First Energy Solutions Corporation. In April of 2018, the commission's technical utility services staff issued a secretarial letter which denied First Energy Solutions' petition to renew its financial security at the 5% level. The secretarial letter referenced First Energy Solutions' recently filed notice of bankruptcy and its subsequent credit rating downgrade. Via order in July of 2014, the commission established procedures by which staff may deny petitions to reduce EGS's financial security requirements. That order stated, for any denial, the Bureau of Technical Utility Services will state how the request is not consistent with the Public Utility Code and the Commission's bonding or security regulations. In its secretarial letter denying First Energy Solutions' bond reduction petition, staff stated that the financial security is designed to and the supply of electricity at retail in accordance with contracts, agreements, and arrangements. Because of Moody's downgrade of First Energy Solutions' rating outlook, we find considerable uncertainty regarding its ability to fulfill its future annual obligations under Section 2809. In particular, we have concerns related to gross receipt taxes, alternate energy portfolio standards, and the Commission's annual fee levied on EGSs. Because of these uncertainties, we believe that it is prudent to return First Energy Solutions 4 quarters of revenue. I submit that renewal is consistent with the procedure established in our July 2000 utilized by staff in the secretarial letter for denial of the petition. Therefore, I move, 1, that the petition for reconsideration of staff action filed by First Energy Solution Corporation be denied, consistent with this motion, and 2, the Office of Special Assistance draft an opinion and order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion?
Let me just make one statement, if I could, Mr. Vice Chairman. As an attorney, more than 5 years ago, I did, which was an acquirer of the refinery that is operated by First Energy Solutions. I do not believe that that prior representation constitutes a conflict in terms of dealing with this particular matter. My statement, however, is somewhat academic because I intend to vote against the interests of First Energy Solution, or at least their petition that's before us today. I will be voting to support the the motion that's made. But in interest of full disclosure, I bring up that that representation in a prior life. Thank you.
Thank you. Commissioner Sweet, any further discussion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries 5-0. Madam Chairman, the gavel is yours.
On the matter as amended by the motion, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Continuing on page 1 of the carry-in agenda from the Office of Special Assistance, it is recommended that the commission adopt the staff recommendation in the complaints filed by SBG Management versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to the top of page 2 of the carry-in agenda, it is recommended that the commission adopt the staff recommendation in the matter of the petition for emergency relief by Senator Dinniman versus the Sunoco Pipeline LP.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Under discussion, I do have a motion for this matter, and I will turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I would like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I would like my motion entered into the record in its entirety, and I will summarize it. Before the Commission is the interim emergency order and certification of material question issued by Administrative Law Judge Barnes on May 24, 2018, which granted the petition of Senator Andrew E. Dinniman. The material question to be answered today is as follows: whether the evidentiary record supports the provisions of the interim emergency order, which enjoins Sunoco from all current operation on Mariner East 1 and enjoins construction, including drilling activities on the Mariner East 2 and Mariner East 2X pipelines, all in West Whiteland Township, Pennsylvania, until the entry of a final commission order in the formal complaint proceeding at this docket number. It is important to point out that the underlying complaint is still before the administrative law judge. Our decision today only addresses whether interim emergency relief in the form of an injunction shutting down the operation of ME1, ME2, and ME2X should be granted. Upon review of the record in this matter, I do not believe that the integrity of ME1 remains at issue, as Sunoco performed all of the necessary steps as directed in that matter to the satisfaction of our Bureau of Investigation and Enforcement. While the record contains accounts of Sunoco's mishaps in other jurisdictions and other pipelines, there is no new credible evidence to support a finding that the continued operation of ME1 poses a clear and present danger to life or property in West Whiteland Township. However, with regard to the construction activities on ME2 and ME2X, I find that Sunoco should provide additional information in the formal complaint proceeding in order for the Commission to determine whether construction can safely restart on these pipelines in West Whiteland Township. Consistent with the interim emergency order, Sunoco is directed to file the following information within 20 days of the entry date of the Commission's order pursuing to this motion. 1, inspection and testing protocols. 2, comprehensive emergency response plans. And 3, current safety training curriculum for employees and contractors. Also, when available, Sunoco is directed to submit verification that the Department of Environmental Protection has issued the appropriate permission for continued construction of Mariner East 2 and Mariner East 2X in West Whiteland Township. Sunoco is reminded that the requirements established in the ex parte emergency order, which was entered May 3, 2018, remain in effect. I also expect that Sunoco will continue to cooperate and work closely with our Bureau of Investigation and Enforcement, including giving advance notice and coordination of any construction, including and especially construction involving drilling. We will not decide today the validity of the remainder of the ALJ's ordering paragraphs, which directs Sunoco to report certain facts, to develop and implement training, to educate the first responders, and to conduct additional tests. We look forward to a closer review through the formal complaint proceeding of Sunoco's geophysical and geotechnical studies and analyses, including I'm just going to.
Resistivity?
Yes, thank you very much. Seismic and gravity in any areas of West Whiteland Township where Sunoco will use HDD. Therefore, I move that the material question certified to the commission is answered in the negative with regard to Mariner East 1 and is answered in the affirmative with regard to Mariner East 2 and Mariner East 2X. 2, that the ALJ's interim emergency order is modified consistent with this motion. 3, that the petition for interim emergency relief filed by Senator Andrew E. Dinniman is granted in part and denied in part consistent with the motion. And 4, that the Commission's Office of Special Assistance prepare an appropriate order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion?
Vice Chairman, I have a joint statement with Commissioner Kennard on this matter.
Commissioner Coleman.
Thank you. I'd ask that our joint statement be entered in the record as though we had read it in its entirety. And let me first start by thanking my team and Commissioner Kennard's team for the excellent work on this matter. This was a fast-moving case with a number of technically challenging parts to it. So I just want to take a moment this morning and recognize the team for doing what I think is an excellent job in summarizing where we are in our statement here this morning. Based on the review of the record and the briefs, we agree that the proposed motion to resume service on the Mariner East line for the reasons set forth in the motion, and I want to emphasize that point this morning. However, we do not agree with the proposed motion on upholding the stay of construction on Mariner East 2 and Mariner East 2X. Therefore, we would answer the material questions in the negative, reverse the interim emergency order, and return the matter to the administrative law judge for further proceedings on the underlying formal complaint at the consolidated docket. On the matter of emergency relief, to obtain emergency relief from the commission, a petitioner must prove that all of the following 4 elements are met. Number 1, his right of relief is clear. Number 2, the need for relief is immediate. 3, that injury would be irreparable if the relief is not granted. And 4, that the relief requested is not injurious to the public interest. We acknowledge that Senator Dinniman has raised substantial legal questions here, and that we understand that the safety concerns expressed by him and others about Mariner 2 and Mariner 2X. Upon review of the record evidence, however, the Senator has not shown that there is an immediate safety threat that warrants halting construction of ME2 and ME2X. Therefore, we do not believe that Senator has met the burden of proof for interim emergency relief. In the interim emergency order, the ALJ found that the need for injunctive relief was immediate for ME2 and ME2X because she was persuaded by the evidence presented by Senator Dinniman and his expert regarding pipeline leaks, inadvertent return issues, and the Pennsylvania Department of Environmental Protection regulation violations. The ALJ also primarily determined that the need for injunctive relief was immediate based upon the incident involving Sunoco's use of unqualified welders in the state of Texas in 2016. Further, the ALJ found that Senator Dinniman established an immediate need for relief based upon potential threats of water source in West Whiteland Township, including aquifer and private wells issued resulting from subsidence or sinkholes related to Sunoco's construction practices on ME2 and ME2X. We don't agree with the ALJ's determination that there is substantive competent evidence that the immediate danger exists with the construction of ME2 and ME2X. Further, the hearing transcript is devoid of any expert witness testimony that, to a reasonable degree of scientific certainty, that there is credible and immediate harm with the construction of these lines. In fact, the senator's own witness testimony expressly denied having an opinion on whether reasonable degree of scientific certainty regarding the inadvertent returns or that any sinkholes would be created with the remaining construction in West Whiteland Township. Second, the evidence in Texas occurring over 2 years ago are not linked to the events in Pennsylvania concerning the Mariner project and have no relevance to a finding of immediate harm in the matter before us. Therefore, we do not believe that it is appropriate to rely upon these events as a basis to conclude that the construction of ME2 and ME2X is an immediate threat to West Whiteland Township. Third, we do not find that an immediate danger can be, by definition, exist with respect to ME2 and ME2X pipelines, as Sunoco cannot currently engage in construction activity of these lines in West Whiteland Township until it receives certain drilling permits from the Department of Environmental Protection. Nevertheless, even if Sunoco does obtain the appropriate drilling permits from DEP in the future, the water quality related issues upon which the ALJ relied appeared to be within the DEP's jurisdiction, not within the Commission's jurisdiction. The extent that the relevant water quality issues may become within our jurisdiction to ensure that Sunoco providers safe and reasonable public utility service, we do not believe that the water quality issues alleged thus far in this proceeding rise to the level of an immediate danger. In any event, Pennsylvania should know that the pipeline safety is a top priority for this commission. To that end, we believe that the motion does not adequately account for the fact that the commission has in-house pipeline safety experts who have been and will continue to actively monitor the construction of ME2 and ME2X. The Commission's Pipeline Safety Division within the Commission's Bureau of Investigation Enforcement works in coordination with the Pipeline Hazardous Materials Safety Administration, or PHMSA, which is the US DOT arm, for the enforcement of all applicable pipeline safety regulations, including those applicable to the operation of ME1, and the construction of ME2 and ME2X. In short, the personnel of our Pipeline Safety Division are the Commission's boots on the ground to administer pipeline safety regulations. The Commission's Pipeline Safety Division played a key role in the investigation and the resolution of the safety issue that arose with ME1 on Lisa Drive in West Whiteland Township. It was the safety issue which led to the request from the Pipeline Safety Division on March 7th of 2018 to temporarily stop service of ME1 pending an investigation. The Commission granted the request and subsequently reinstated service on ME1 on May 3rd, 2018, based primarily on the Pipeline Safety Division's agreement following extensive testing and analysis that it was safe to resume service. The proceedings showed that the Commission's own pipeline safety experts are actively and fully engaged with Sunoco's Mariner project and are ready, willing, and able to take the necessary steps to protect public when it comes to safety. Our Pipeline Safety Division also has played a key role in helping ensure the safe construction of ME2 and ME2X. Also noted in the Commission's written testimony before the Pennsylvania Senate, our Pipeline Safety Division devoted significant resources over the past several years to Sunoco and Mariner project. Our Pipeline Safety Division spent 76 inspection days during 2017 on the Mariner project. Our inspectors are continuing this rigorous inspection program throughout the construction. The Commission also will continue to monitor the inspection of Mariner project after construction is completed and consistent with the duties of enforcement of the federal pipeline safety law. To date, the Commission's pipeline safety experts have not reported any safety issues that warrant halting the construction of ME2 and ME2X. Let me restate that one more time. To date, this Commission's pipeline safety experts have not reported any safety issues that warrant halting of construction of ME2 or ME2X. However, our experience with ME1 shows we have full confidence in our Pipeline Safety Division will take the necessary steps to protect the public if the safety issue arises from the project. Nevertheless, out of an abundance of caution, we request that our Pipeline Safety Division review the transcript of this matter and take what action they believe is necessary and deemed appropriate. For these reasons, we do not support the proposed motion this morning. Thank you, Vice Chairman.
Okay. Any further discussion? Hearing none. All those in favor signify by saying aye.
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 Aye. Any opposed?
Opposed?
The motion carries 3-2, noting the dissents of Commissioner Coleman and Commissioner Kennard. Chairman, the gavel is yours.
On the matter as amended, if there's no further discussion, if there's no objection, we'll take the previous roll call. The matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard.
Continuing on page 2 of the carry-in agenda from the Bureau of Technical Utility Services, it is recommended that the commission adopt the staff recommendation regarding the rate increase proposal of the York Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3 of the carry-in agenda from the Law Bureau, in an omnibus motion, it is recommended the commission adopt all of the items on page 3, as well as the first 2 items on page 4, including and ending with the petition for reconsideration of the Pike County Light and Power Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And Madam Chairman, the final carry-in agenda is the motion of Commissioner Kennard regarding jurisdiction over pole attachments from the FCC.
I recognize Commissioner Kennard for his motion.
Thank you, Madam Chairman. One of the mainstays of delivery of telecommunications and electric service is so commonplace as to be virtually invisible. Speaking about utility poles and the countless miles of wire and equipment that comprise the physical backbone of utility facilities. These humble poles and the wires, lines, and equipment they carry ensure safe and reliable delivery of electricity, communications, cable, telecommunications, data, and much more to millions of Americans and millions of Pennsylvanians every moment of every day. Under the 1996 Telecommunications Act, pole owners and attaching entities fall under either federal jurisdiction by default or state regulation if the state expresses an interest in regulating poles. It's something called reverse preemption, which to my experience is novel and singularly attributable to this 1996 Act. The Pennsylvania Public Utility Commission has not thus far elected to regulate pole attachments, and thus jurisdiction still resides at the FCC. I propose that the commission now make that